Vesta has been around for about the last 14 years, and the Carlsbad Hub has been here since 2019 in California. Vesta really established itself because it wanted to help people change the way you divorce. That's been their mission from the beginning. What they do, which is really helpful to you, they go out into the professional community and they find us and they basically find who are the people that are most respected, top professionals within their communities. They interview us, they vet us for you, and then we form these hubs that are geographically oriented. So we are in the Carlsbad Hub of Vested Divorce. Let us all introduce ourselves to explain maybe the breadth of our work. If you're here tonight and you're not a California resident, some of the tips we're going to be offering you won't necessarily apply, but some of them are germane to anybody getting a divorce. This is a community property state here in California, so some of this won't be applicable to all states. So once again, thanks for being here. My name's Laura McGee. I am a divorce mediator. That's my primary work. I'm also a divorce coach where I work with individuals behind the scenes. Sometimes they're litigating, sometimes with a different mediator. Sometimes they just are preparing for the idea of divorce, and I work more as a strategist. Because of my legal training, I'm focusing not on necessarily the therapeutic aspect of helping you through divorce, but some of the legal strategies and things help you set some expectations. I'm also a co-parenting specialist, and that plays a role both in my mediation practice, working with couples that have children of any age, because even adult children experience their parents' divorce. So we talk about that even when you have adult children. And sometimes with parents that never married and they're just separating out and they're not going to live in the same household. And sometimes in my coaching practice, trying to help people come up with realistic expectations for life after divorce. So those are the roles that I play. I work with anyone, any couple, any individual throughout California, because I can work online and I can file in any jurisdiction if you're mediating. And so that's what the nature of my practice is and where I'm able to practice. And Ken, do you want to introduce yourself?
Sure. Thank you, Lauren. Thank you, everyone, for joining us this evening. I'm the family law attorney in the hub, and my entire practice is dedicated to family law. That's all I do. So I primarily engage in litigation, which is going to court and fighting about stuff. But I deal with all stages and all facets of a divorce, whether it's the beginning where someone's filing a petition or a response, all the issues that come up in a divorce, whether it's child custody, visitation, child support, spouse support, dividing assets and debts, so on and so forth. And I also have many cases that arise after a divorce is final. Many times there's a modification of support or modification of custody or visitation, or a parent wants to move away. Different things come up, and I have many cases in that realm of the divorce phase as well. I also, though, even though they heavily involved in litigation, I do serve as a consulting attorney in many cases where we'll talk about more in detail, but bottom line is I can essentially be a coach to someone involved in mediation. I'm not going in there, but can advise them as they prepare for and participate in the mediation. And I also have cases where not in mediation or not in litigation, but I represent one spouse and the other spouse is also represented. And I work with the other side's attorney to negotiate and ultimately reach a resolution. And even though it is not as efficient and cost effective as mediation, it's still exponentially cheaper and quicker than the litigated route. So that's the kind of overview of my practice. And I'm glad you're all here with us tonight. With that, I'll turn it over to Emily, our mortgage broker.
Great. Thank you, Ken. Welcome, everyone. I'm happy to be here. I'm the mortgage broker for the Carlsbad Hub. I've been certified in divorce and owned a mortgage company in Encinitas for the last 20 years. Over that time, I've seen hundreds of divorces, some very amicable and some kind of the furthest from. So I help people navigate most likely is the largest asset, which is the family home. In some cases, I do have clients that have multiple properties, and that's when Laura will come in or Jennifer, when our awesome real estate agent, and help us navigate or trade and figure out what that process will look like financially. But our goal here is to offer you a plethora of decisions and support and an education on when you're making some of these very critical decisions. I've seen in my past, a lot of the idea is to just sell assets as quickly as possible and split ways. And sometimes that's not the best way to go, especially with the interest rates in this market changing so quickly and values changing and doing their thing at the same time. So what I offer is we really drill down to what the important aspects of the family are, to offer you more options, more support. A discovery phase, we do a complimentary session on just looking at what assets are available, what the goals of the family are, especially when it comes to that family home and any other real estate that's owned. I work closely with Jennifer Cheney, who we're missing her here tonight, but she's our amazing realtor. She loves to sit with her clients and offer a CMA, a comparative market analysis, just to value everything, really put a price tag on the assets that we're looking at, just so you can help educate you and decide what makes the most sense during that discovery zone. And yeah, we love what we do. And this is a great team, Laura and Ken. They're amazing humans that really have your best intentions in mind. So this is a really supportive staff.
Yeah, thank you so much.
Yeah.
And so I probably should mention that we usually have a CDFA, a certified divorce financial analyst. And so when you think about divorce, think about building a team. It takes a village to get through this. And then also we're going to talk a bit about the preparatory stage, because information is going to be your superpower. And the correct information will be your super duper power. Oftentimes you have these whispers or people are going on ChatGPT, but you don't know what to ask. And these can be good resources, but you want to make sure you're getting the information that's relevant to your state, sometimes even your county, because Ken will tell you sometimes the judge that you've been allocated can make a difference between how a case flows. And definitely knowing that in the preliminary stages, if any of you are still in the contemplation stage, the biggest tip to save you thousands is to collect as much information about the financial wherewithal of your entire family as you can. And sometimes when I'm coaching, I find it particularly with women, they're like, I don't want to look, I'm snooping. And what I say is, look, you are in the business of raising a family. One of the things you're doing as a family is you're operating a business. Would you be in a business relationship with somebody that never opened their books to you? Probably not. Probably not. Shouldn't you have a chief executive marketing meeting at least annually at tax time? Are we going to invest our money? Are we going to go on vacation this year? Are we saving for college? Do we have any money in retirement? Who needs to work more? Can somebody work less to be more focused parenting? All of these things, unfortunately, if they're not negotiated and discussed during your marriage, they often are a very central part of why the marriage broke down in the first place, because money is about values. And everybody has a personality around money. Somebody's maybe a saver, someone's a spender because they expect a big inheritance later. I actually have a couple right now, literally. Husband came from a world of lack and he's like squirrel. And she comes from a world where there's significant money to come her way in time. And she's like, her retirement, and they've lived, as I'm finding many couples that are in their mid 40s, in that age range, they've never lived like a couple. They don't have joint accounts. He pays for the this and that, and she pays for the that and this, and they don't have discussions about it. She's got credit card debt. He doesn't. He paid off his student loan. She didn't. She's got $50,000 in retirement. He's got $350,000 in retirement. And now we're talking about this as community property. And unfortunately, it's tense because they lived in a world where there was no us in this marriage. It was me and you and some children that they brought into the world. If that's been your marriage, sometimes it's really hard to get information because everything's online these days. It's not like the mail comes and you can open up a statement, which you probably shouldn't do anyway. But you and Al Capone going to go down for mail fraud.
Yeah.
But what's wrong with asking? And I mean, at tax time is almost the best time because you share your.
Everything's coming in.
If you have a W-2 employee, learn how to read. This is an important tip. Learn how to read a W-2. Go to box 5. That's your gross earnings. That's before you were taxed. Look at box 12. Find out if they were saving for retirement. Find out how much the health insurance, it's all on your W-2. And most people have never read a W-2. And at the bottom of your W-2, it says what each box means. And if you don't have the bottom of it, you can literally ask ChatGPT. I have a W-2 in front of me, and don't put it in ChatGPT because you need to anonymize it. That's giving too much personal information. But if you really needed to, or you can just ask your CPA, worst case, your HR department, hey, what does this mean? So preliminary first stage, be curious as opposed to judgmental, meaning, I'm curious, like, how much do you save for retirement? Because I don't know if we're doing the same thing. I'm curious. If we say, like, you've never given me your retire, I don't know what you're doing. You're hiding everything from me. Probably not going to get much information. So just in a preliminary way, I would say the first step is if you're in early stages or in even early stages of discussing, and you're going to have to do disclosures. So Ken, why don't you explain what the minimum legal requirements are here in California? Because I think it's
Sure.
worth understanding that from an attorney's.
Certainly. So in California, there's this process called the preliminary declaration of disclosure. And what that is, every single divorce case, it doesn't matter how amicable it may be or how nasty it may be, the law requires that this financial disclosure process happen. And it's pretty regimented in the sense that it's very form driven, but it's also helpful because it's designed to force people to collect what's required to be disclosed. So the first form you'll run into is called the FL 150. It's the income and expense declaration. So as the name implies, you have to list out all your income and other expenses. But along with that, if you're a W-2 employee, like most people are, you're supposed to also attach your last 2 months of pay stubs. Also, along the lines of income and such, as a part of this financial disclosure process, both sides are also required to exchange their last 2 years of tax returns. So that's also very helpful. A lot of times it's easy because people file joint and they've been doing that the whole marriage, and okay, it's nothing new. But a lot of times it's difficult because one party really managed all the finances and the others didn't. So it's an eye opener for them, or they don't really understand what they're looking at. But the point is, this financial disclosure process is supposed to enlighten everyone about the financial picture. The other part of these required financial disclosures are the FL 142. That's the name of the form, but it's titled Schedule of Assets and Debts. And again, like the name implies, you have to list out all of your assets, all of your debts, and it's an organized form. It's got categories such as real estate, checking accounts, savings accounts, brokerage accounts, retirement accounts, whether it's 401ks, IRAs, along with all your debts, whether it's credit cards, personal loans, what have you. Along with having to list all of the information about those assets and debts, the requirement also is for, again, both sides to also attach the most recent month statements that correspond to each asset or debt. So this process is designed to, Laura says it best, what do you call it? Cards up poker or whatever.
So face up poker.
Yeah, face up poker. So everybody knows what the real financial landscape is. So you know what the box is of assets and debts that you have to honestly deal with in working out and dividing in your divorce. It also is supposed to lay out what is the financial picture as far as both sides' incomes, because that also is going to be relevant in calculating child support, if applicable, as well as spousal support. So that's a crucial step in any divorce that has to happen. Literally, the law does not allow people to be divorced unless that disclosure process takes place. So that's what Laura's saying, the bare minimum. That's the starting point that everyone has to do who's getting divorced. So that's the starting point of how it works in the financial disclosure process.
Yeah. And it's interesting. Sometimes when people come into the mediated environment, they think they can skip the step. They're like, oh, we've had a conversation. It's okay. We're just going to sign. We already know what we want to do. And you can't actually do that. You have to sign another form. So the forms that Ken's talking about, if you're mediated, the nice thing is mediation is confidential. We don't put any of those documents in the court. Your FL 150, if you're litigating, it goes right in the court. And the 142 doesn't, but some people file what's called FL 160, and that puts everything in the court. So If you want some privacy, don't do that one because you don't have to put it that way.
Yeah.
So if you're looking up these forms online, they're all judicial forms. So FL for family law dash 150, FL dash 142. So in a preparation, again, tips to save you literally thousands. If you take agency over your divorce, it's not something that happens to you passively. This is an active episode in your life. Divorce doesn't just happen while you watch it go by. If you do that, you will not save thousands. You'll spend tens, hundreds of thousands because you're expecting it to go all the way to a judge to decide for you. That's the most expensive way possible. So even if you're mediating, you have to do this step. And it asks you to list what you know. And say you know that your spouse has a student loan. You just don't know how much it is. You can say, husband's student loan or wife's student loan, TBD.
List it anyway.
Yeah, because you're alerting that I'm expecting you to turn up with a document. Because the FL 142 is a table of contents, and you are both required to do it. The nice thing in mediation is I have my clients quite often, not all the times, because sometimes they're living very separately, but I have them do it together quite often. It's the first collaboration. It's an opportunity to already sit down and go, hey, I've got the form. I don't mind working with it. Like real estate. You pretty much know if you have more than one piece of real estate, but you might have a timeshare and you might have a HELOC and a solar loan. So all these things have to be deducted, and maybe the statements are online and you haven't looked at them. So you don't really know what you owe. So each of these things will have a statement and it's categorized. It's called categories. But a place where sometimes assets get missed, which we're going to talk about next month, and a place worth looking, I'll see that there's a 401k. And if you go look on the pay stub, which is required for the initial FL 150, Ken talked about 2 months of pay stubs. What are the things you're looking for? Just to get yourself educated. Is there a 401k loan? That means your spouse borrowed from the community property, most likely community property 401k, which is a retirement asset that belongs to both of you or potentially does. And it's being repaid with post-tax dollars out of your spouse's pay stub. So less money's coming home. Do you know what that money was borrowed from? Maybe you agreed. Maybe you did it for renovation on the house, something like that. You're just looking like you want to be able to read a pay stub and read a W-2 as well. And the pay stub will say, is any 401k being deducted? Are they a PERS or a STIRS? Are they a teacher, a public employee, military, police officer, fireman? The pay stubs are complicated. But the more you can demystify and take agency again, it's like, I don't know what that means. That's weird. Engage, deeply engage, educate yourself. And if you can't do it on your own, that's where you build your support team. Get this explained. Because quite often I've had people come in and like, oh, I'm sure that my spouse makes $200,000 a year. And then we get the pay stubs and there's gross income, which is before your tax. And maybe it's close to that, but it's a fireman. And guess what? 1 year he did because all the fires, lots of it was overtime.
Yeah.
That's not necessarily the regular income. And it doesn't mean it's not part of the discussion about support, but we want to know, what's your salary? Do you get bonuses? Do you have commission? Do you get stock? Do you have overtime? Do you have tips that aren't taxed anymore? Think of all the things we have to talk about before we can get to all kinds of financial decisions that need to be made. So I hope there's some wheels turning back there. Something as simple that's probably available to you. And then Ken made a comment that you're going to have to exchange at least 2 years of taxes. So that's if your W-2 employee is fairly stable. If you can't get your hands on your taxes and you don't want to call your spouse's CPA, who's really yours, you can go onto the IRS website and you can order your tax transcripts. Yeah, they're free because they're yours. And so don't have them mailed to your door if you're not in conversation. You can get them emailed. So there's another place to go get your tax information if you're the person that I never even signed my taxes. I hear this quite often, which is a shame that CPA just did them and I never even saw them. So that's a place that you can go and get information. If you've never gone onto your own Social Security website, please do. You do have to register. Social Security is not divisible by a state because it's a federal benefit. It's not, but it plays into support. So what if your spouse is potentially going to receive $4,000 a month at full age of Social Security, and yours is looking like $800? There's what's called divorced spouse Social Security. It doesn't come from your spouse. It comes from the federal program. and they top you up. So now you have 2,000, they top you up to 50%. You'd like to know that because in the spousal support negotiations, you'd like to know, where will I be when I hit full age of Social Security, when I want to start collecting it? All of these data points start to build a picture. Imagine you've got one of those 500-piece puzzles and you're collecting all the pieces. So at the end of the day, you see what this puzzle really looks like. That's what you're trying to collect. Lots of data collection. So, Ken, what happens if it's not voluntarily exchanged?
Yeah, that can get complicated and very expensive. So there is a process by which, if you are receiving the other side's disclosures and you see here that it's not complete, you're supposed to try to meet and confer, meaning informally resolve it. I'll send a letter to the other side and be like, look, my client has identified that there's things missing. There's these other 401ks that are not listed. There's a brokerage account that she knows is there, or he knows is there, just not listed. And you can try to, hopefully at that point, the other side would be like, come clean, like, okay, we forgot, whatever. But if that doesn't work out, then you're going to be stuck going into the world of discovery. And that's a process by which both sides are entitled to use different tools under the law to find information. In this case, financial information. And that can take the form of interrogatories, which is where you submit written questions to the other side and they're required to respond to them under oath. You can submit demands for production of documents, where you can make a demand to the other side to produce documents related to whatever financial accounts, so on and so forth. It's a very extensive process. If you want to go down that road, you can go to the point of conducting depositions, where the other side will be compelled to come in and sit before a court reporter and answer questions, review documents and answer questions about documents, about finances and so on and so forth, and under oath. So it can get extremely expensive really fast. I get the question a lot about subpoenas. Yeah, you can do that, but it's not like you just fill out a form and shoot it off. There's a lot of moving parts to that. It has to be properly served on the bank or the financial entity. You have to have a deposition officer, which is a procedural requirement, but each aspect of the subpoena process involves somebody being charging you something for it. And then once the documents are collected, and you don't just get, oh, here's a nice summary. Whatever you request, there's a massive pile of documents that come in, and guess what? It's not like the other side's like, oh yeah, what you're looking for is on page 3 of 50,000. You got to sit there and look through it, or your attorney and the paralegal and staff have to look through it, which results in obviously legal fees. So the answer is, if they're not cooperative, the other side's not cooperative, there are ways to deal with it, but it can be very expensive, and a really careful and serious conversation needs to happen between you and your attorney, or with yourself, with regards to a cost-benefit analysis. Because so many times you'll see, and I've actually been on the receiving end of this, where there's one spouse who's absolutely convinced that the other spouse is hiding stuff. That's just happening. It is absolutely happening. And the discovery avalanche happens. Everything, all the way through producing documents, thousands of pages, hours of deposed testimony. And it turns out sometimes literally there was nothing. Or I had a case where, there was one account that was missed that literally a spouse had before they got married. It had like $45 in it. It just sat there. I mean, so the point is, I always have a very serious conversation with my clients about, we really got to make a serious assessment. Is it worth it? Because discovery is something that can get really expensive really fast. So yes, there's tools, but be careful on how you use them, is what I'd say.
Right.
As far as
And
saving costs.
yeah, and a tip related to that to save money is, again, back to taking agency. Because in mediation, we don't have power of subpoena. So I often have clients, I have one right now. She goes, I know my husband has multiple accounts, money's moving around, and he does have a gambling issue, and she's not wrong. So I said, let's start this way. Let's pull up the last 12 months of his bank statements, and he had more than one bank account. And you just read them, which I know sounds crazy, but guess what? Every time money moves out, there's a line item. Went to another account number, wire transfer, went to And if he hasn't produced those statements, then there's another bank statement we're looking for.
Yeah.
And in this particular case, because husband wants the confidentiality, mediation is confidential, and he doesn't want to lose his job. And there's been a lot of what we would call marital waste, where he's spent significant amount of money on a non-marital purpose. So she has a right of reimbursement, and the right of reimbursement is sometimes confusing for people. So if he wasted $100,000 gambling net of his winnings, which usually the net is a negative, she doesn't get 100,000. A lot of people start with, if he got 100, I get 100. 50,000 of what was spent was community money. So she would get $50,000. Now, if he wasted $10,000 and you're going to spend $25,000 on subpoenas and discovery, like Ken is talking about, and you get your 5,000 back, you're not ahead. You're not ahead. So that's what Ken's talking about. So sometimes you can start your discovery without a subpoena if you at least have at least a primary bank account. The paycheck goes in, and guess what else you can do? Look at the bottom of the paycheck. You know what it says? It says which accounts it goes into.
Yep.
And so you're like, the paycheck tells you a lot. I had one recently where it was going 3 places. I'm like, I don't see those accounts in your disclosures. I only see the one. Oh, this one's for our children. I didn't think I have to put it down. For the children account had over $100,000 in it, and wife wasn't aware of it. And it was not a FBO, not for benefit of demarked or custodian account. So he might have wanted it to be for the children in good faith. I'm going to assume that for now. But guess what? It's community assets. They belong to both of you. And then you can choose if you want to use it for your children. If you can afford to use it for your children, maybe you'd like to, but maybe now you can't. You can't afford to. And then there was another account, and that was actually going, as it turned out, to his sister, who he said he was helping out, but he's helping out with community money. Back to the pay stub, back to the W-2, back to actually sitting down and reading. Ken and I worked on a case where he was consulting attorney, and husband had been involved in extramarital affairs and was spending money in that regard. And she wanted to be compensated, which she's entitled to be. And literally, that's how she did it. Rather than hiring an expert, she just got out her blue pen for him and a pink pen for her, highlighter.
Yep.
And they each had consulting attorneys, because sometimes in mediation, if there's an impasse, I'm like, bring your attorneys in. We fixed the impasse. It got solved. Ken, there was no subpoenas, right?
No, none. No formal discovery. We were able to work it out at a fraction.
Yeah, a fraction of what it would have cost.
Yeah.
And honestly, the recovery to her was around $17,000. It wouldn't have made sense to do the discovery. But again, husband wanted privacy. And I have another new tip for you. My client who's got the gambling issue, he's a very sophisticated engineer. He said to his wife and to me, by the way, there are apps out there that will literally scrape. If I tell it that I want it to look for crypto deposits, name every Coinbase and all the sites I gamble on and all the porn sites I go to. He goes, I'm going to put them all in, and I'm going to feed it 700 pages of banking documents that he voluntarily produced. And it is going to scrape it for us as AI. And it is going to tell us how much. He goes, I don't mind finding out how much I wasted. Maybe it'll help me with my gambling problem. He goes, because I wish I didn't. But he actually said I didn't know that. So that was brand new information just this week. And I said, I want to know what those apps are. So that's coming up. My June 2nd mediation with him, with both of them. He's producing the data and even his methodology of how he did it. He's being fully transparent, which you have to completely honor. Unfortunately, he's struggling with an addiction. He acknowledges that, getting some support right now. And he has remorse. And he's agreeing to repair for it, which is what the law. Ken, you want to explain this right of reimbursement when it's a non-community purpose?
Sure. So the law starts with an assumption. It starts, I think, any income or assets acquired during the marriage is community. It also starts with the assumption that any expenditures that occur during the marriage are for the purpose of the community. And the law also imposes a duty, whether the parties knew it or not, called a fiduciary duty to one another, where they're supposed to always act in the most upright, honest, forthright, transparent way to one another with regards to using any community income or assets. So that's the starting point of how the law views the landscape of finances during a marriage. So if there's one party who deviates from that, meaning they use money for non-community purposes, and frankly, I know there's different flavors of it, and I get arguments sometimes, but let's face it, it's the classic, you'll know it when you see it. Extramarital affairs. Again, no false state. I don't want to cause confusion here, but infidelity is not a grounds for divorce, and it doesn't affect support or anything like that. But if you're using money, like in the case Laura and I were involved in, for hotel rooms, encounters with the other person, obviously that's a non-community purpose. The gambling scenario, obviously, isn't that prostitution, that type of thing. Obviously, these are clearly non-community purposes. So when things like that happen, that creates, under the law, the right of reimbursement to the aggrieved party, the spouse who wasn't doing that misbehavior, to receive compensation back from those amounts that were being used for non-community purposes. So that's the whole legal approach of how to assess that.
Perfect. So starting points, getting a hold of a pay stub, learning how to read it.
W-2,
Yep. W-2, learning how to read it. And at least one set of primary bank statements so you can see where the money's going. That's a starting point. That'll literally save you thousands. I want to talk a little bit about self-employed people because not everybody's W-2.
good point.
And sometimes when I had people I had a couple in here where she was a hairdresser and he's a handyman. And they owned a home that apparently made $20,000 a year. So without a mortgage on it, by the way. Both had nice cars. So it's pretty clear there's money. And I've done pot farmers as well, where it's all cash all over the place. So a system that I suggest, if you have a high cash type of revenue in the family, you won't find it all. So don't start subpoenaing for a picture of cash somewhere. So just surrender to the idea that cash is going to be harder to find, but you can measure lifestyle. So what I say, okay, let's take a 12-month period. I want you to go back and see, this couple was harder because they didn't have a mortgage, but quite often you've got a mortgage. How much did you have? What did you owe on your house? How much did you have in savings? Did you have any credit card debt? Were you funding an education fund or a retirement fund? Was any of this happening? What was your status quo at month 1? Look at 12 months. What did you spend every month to live? Did you have a car payment? Did you have to pay a mortgage? Did you go out for dinner a lot? Did you get DoorDash people? Whatever you are. We're spending $10,000 and we have more savings than we had at month 1 on month 12. Less, like that's the framework. Clearly, there's that much money in the family that we can start talking about. And again, because mediation offers confidentiality, I find I often am mediating with where there's one of the parties, it has addiction of some kind. There's lots of cash floating around. Like I said, I've done several pot farmers. I think they found me and then more found me. I've done a lot of cash type people where you're not going to really find every nickel for sure, but we can talk about it more in terms of a lifestyle. And they show up in my office and they've got their Vente Starbucks and this $200 running shoes on, and they pulled up in their F-150 Supernova truck. And I'm like, okay, you only made $13,000 last year. Let's talk about that. Let's talk about how it shows up in other ways. And the practice is to stay curious as opposed to when you make a you statement in a mediated environment, you're talking to each other, whereas Ken gets to be the buffer. But when people are speaking to each other, when you make a you statement, you've always started an argument. You tends to go with always or never. You always, you never. And it's the beginning of a blame statement. An I statement, I'm curious. I wonder how we managed to have all this stuff in our lives and only make $13,000 a year. So I'm curious about that. Can you deconstruct this for me? How does that work? And these kinds of questions that I do, even as a mediator and as a coach, I'm often helping people to find the language that will support proposals and a true negotiation instead of an argument. I don't have a whistle. I'm not a referee. I don't manage arguments. I'm like, okay, is that a proposal? Because it doesn't sound like one, but maybe there's a proposal in there somewhere. Tell me what that looks like. So in this process, it can be if you feel like you are trying to save money, but you're also feeling like there must be something more here. if you practice curiosity and I statements, you're more likely to be in conversation instead of conflict with one another. Okay. We'll be talking more about this next month, but I just thought sometimes next one, self-employed, they have an S Corp. So in California, everybody loves an S Corp that's self-employed. S for, I don't know, insanity. So your S Corp means that most of you earn $60,000 on your W-2, and the rest is run through the company and it pays for your car and your car insurance and your registration and your gas and your dry cleaning and your gym membership and all kinds of things. So we just have to identify those and we call them perks. If you work for a big company and they gave you all these as perks, it's added into the child and spousal support calculator as untaxed income. Sometimes people are willing to fess up. They're like, yeah, all this stuff, here's what we run through their S Corp. And sometimes we need a CDFA, somebody like Lori, who's going to be here next month to talk about this. So when you're building a team, diagnose first. Don't start with a brain surgeon if you have a headache, okay? Take an aspirin and see if it goes away. So everything we're telling you about saving money is don't start with the most expensive shark for an attorney and the CDFA right off the bat and all the most expensive possibilities. Try to stay grounded and curious and take agency in learning how to read your own documents to the extent that you can get your hands on them. And like I say, if you can just go to the IRS and get your transcripts, you're already ahead of the game. It's something as simple as that. So that's just talking about saving money on what could become litigated versus mediated. I want to bring Emily in, who's been patiently listening to us. Emily is an amazing lender, and she's part of our real estate team. And fortunately, Jennifer had a nice family event tonight, so she couldn't join us. So fortunate for her, unfortunate for you. But the good news is we've all worked together as a team for a number of years now, and so we're able to share with you what Jennifer would want you to know. So let's bring Emily in to be our star, and we'll Q&A it out of you, Emily.
Sure, absolutely. Yeah, I could listen to you, Laura and Ken, all day. I love the stories because it's real life. It's what's really happening. You can't make some of those things up. But it is nice to see that it's like people do wild things in times of stress. And there is a way to find salvation at the end and a happy medium. And the two of you make that happen for families. So I love that.
Yeah, thank you. Yeah.
Yeah.
One of the things that gets to happen in mediated divorces is quite often somebody is going to try to buy out the other person, assume a mortgage, potentially delay a sale where they're going to nest in the home possibly. Children will stay and they'll take turns leaving and they'll wait till the child's out of high school, for example. These are creative options that happen in a mediated context. And we'll tell you, they don't happen in the litigated context. In fact, one of our colleagues said to me, if you're litigating, nobody gets the house because everybody's legal fees are too high. So we don't have to worry about all these creative things that you get to do, Laura.
Yeah.
Well, Emily, I think it's worth people hear the word assumption. And tell everybody a little bit about what is an assumption. Of course, that's going to save within a family context significant right now. So let's talk a little bit.
Yeah, no, I think it's great if it's a possibility because just like you said, Laura, there really are two options when it comes to the family home. It's either sell the home, retain the home, or defer the sale, or the nesting. We have seen some of that happening with the family staying together just until the children are of age and off to college. So one of the most wonderful things, because if you did obtain a rate in the 2s or 3s, like over COVID era when everybody was refinancing and really kind of jumping on these rates, an assumption of that type of loan is just priceless. We're just not going to ever, I think, in our lifetime see those rates again. Hopefully we see lower than where we're currently at right now, which is in the high 5s, low 6s. But that's a significant increase. And it can make affordability a lot more difficult for people. So that's a lot of what we discuss, Jennifer and I, when they do drill down on what makes sense. It's normally the wife that wants to keep the family home because maybe she might have more custody time with the children and she wants to maintain that balance and that stability. So that might be very important. But there's so much more that goes into just making that mortgage payment every month. It's also, what is the maintenance on that home? What did the spouse do that maybe you didn't even know that he did? I had a situation recently, a large property in Olevenhain, and there was just acreage and maintenance on the home and appliances and a lot of the things that she didn't really notice that he was taking care of, that all of a sudden became a bill to her, like taking care of the pool, and they had all the gardening, just overall maintenance when something broke on the property. His spouse was there to kind of help maintain in general. So being there by herself was just overwhelming over time. So it just made sense to sell. But we also start talking about capital gains when a decision like that is made. As a married couple, you can each have that $250,000 capital gain deduction in a sale. Once you're divorced, you only have that 250. So there's a lot of tax repercussions, especially in California. Also, Prop 19, if you're changing your tax basis, if you're 55 and up, you can retain that tax basis and move it to another property. If you're not, and there wasn't a natural disaster that happened, you're moving, say if you purchase another $2 million property or $1 million property or anything in that arena, your tax basis is jumping up to 1 1/8 and 1 1/4 on whatever that per new purchase price is. So there's just a lot of little moving pieces that I think when people are going through such a dramatic change in their environment and their family life, when there's this feeling to, hey, let's just relinquish everything and cut parts and take what's ours. In reality, if you sit back and work with a team like us, because that's our job, is to not only educate and support, but also just provide answers that maybe they're just not even seeing quite yet, or just opportunities that maybe that's just they might be a little bit blinded or just confused at the moment. So that's what I love working with Jennifer on that, because we really distill down if they do want to sell that property, what that looks like. Do they want to rent for a little while and just see where that next path takes them? Do they want to purchase again? And what does purchasing again mean? What is their affordability level? What is their whole financial readiness look like? What are the current debts that they're paying on? What are their overall monthly obligations? And then just planning around that scenario. So yes, I actually have a client just recently that he agreed to let her assume the mortgage, 2.75%. Beautiful, lots of equity in the property. Luckily, they had other properties that she was able to exchange out of and just retain the home, retain the equity. And it was a nice, comfortable payment for her to accomplish that. So there's just every situation is so different, and everybody's financial makeup is so different, and wants and needs are incredibly different. So it's us just distilling that down to what are their goals and how can we help get there.
Yeah. And I like that you said that, what are your goals? And sometimes there's the conflict, I often say, lives between an expectation and your reality. So we're trying to shrink this distance. And expectation is often, if it's not based on the correct information, it's based on entitlement or anger or fear, the gap's gonna keep growing. So when we talk about the resources here, for example, if I have clients in mediation and I've had it where I want to buy you out. No, I want to buy you out. No, we both want the homes. What's the first thing we need to know? What's the very first thing? I got to send them to Jennifer or another realtor, and not their sister, brother, uncle, aunt who isn't even in the market. A really active realtor who knows this is what this home would likely sell for, and we want you to list what's the deferred maintenance. The roof is already 20 years old, and we never did fix the broken bathroom because we don't use that one or something. So you make a list of deferred maintenance. You bring in a realtor that's experienced. Jennifer's amazing. She's local here to the San Diego area, so she can't work for you specifically, but she also could connect you with another realtor. But what she does is different than somebody who's just a realtor. A, she's active in the market. B, she's specialized in the divorce world, and so she understands kind of the nuance. So sometimes people will go to Zillow, Redfin, Realtor.com, and that's fine to put a pin in it. But if you're can you imagine if you went to buy a home and it does happen, Zillow puts it on the market, but guess what? They just buy it and resell it, right? If you were going to list your own home, would you just list it for whatever Zillow said? Just a fair market buyer out in the street. So if you want to buy out your partner, first tip is you are a fair market buyer, okay? And you're going to show up and you're going to be negotiating with yourself and your spouse because you are the owners. So it's a rather strange predicament. And how Jennifer could even help you, and Emily, is, first of all, can I afford this? Because maybe I can assume the mortgage, but I have to get a HELOC or I have to take a 401k loan to bridge the distance to buy my spouse out. So you don't look at just, oh, I got this great mortgage rate and I want to keep it. It's only $2,000 a month, but it's not impounded. The taxes aren't on it. Guess what? The homeowner's insurance keeps going up. Guess what? There's a bunch of deferred maintenance. Guess what? You still have to borrow more money to buy them out.
It's true. Yeah.
And so who's going to help you do all that math? First of all, Jennifer is going to give you the real value of your home. And then Emily can be in conversation with you about if this is what you would need to even qualify for the assumption. Emily? Qualify because you can't just assume it because it's not like an assumption in the world, like, oh, I assume I get to qualify it. No.
Yeah.
To assume it? They don't assume it.
Exactly.
Yeah.
Yeah, I think it depends on the lender, but it literally is a phone call. You make a phone call on your mortgage statement and it'll say customer service. You call them and they have a whole, if they do allow for assumability, they have a whole assumability division that they'll direct you to. And then normally they send you out a packet, and then that packet, they want to see your full divorce decree. They want to see your income statements. So they're going to qualify you as if you were just doing a normal refinance. But the beauty of assumability is that none of the terms are staying the same. So you'll probably keep the same amount of year. If you're 25 years into a 30-year mortgage, you're going to still be 25 years in, and then you'll still have the same interest rate. But they just have to make sure that you can assume that loan and still make your monthly payments comfortably. Yeah.
Right. And so I hope the tips you're getting here are that, first of all, you need to know what is the fair market value of the home. And then if you're the one that wants to buy it out, are you going to be able to qualify on your own post-divorce income? So the reason what Emily just said was so key, a bank won't even consider your application without the final judgment for divorce. Here in California, we call it a judgment and everyone else calls it a decree, but it's the same thing. And what they want to see is, are you obligated to pay support or are you the recipient of it? And do you carry a whole bunch of credit card debt or consumer debt that you're also obligated to pay off as part of your marital settlement agreement? And because they'll use that to evaluate whether you qualify. And so, Jennifer, if they're going to get support, what are some of the qualifying tips that are going to be really important if they're hoping to buy out a home and then qualify for refinance or an assumption?
Yeah. So we're obviously going to look at, just to buy. It's the same process. But with divorce, I'm finding that a lot of lenders are becoming a lot more liberal with proving alimony and child support. It used to be like 6 months to a year. They want to show those payments being made, but I've had lenders accept them after just 2 months of payment. So they're becoming a little more lenient with those type of steps. Again, with child support, they want to see a 3-year continuance. So that usually ends at year 18. So you can't have a 16-year-old looking to use that income for the next 2 years because that's all you have left on that. But alimony will use any type of income. There's also some really creative loans that are coming out that are asset based. So it's called an asset depletion loan. So if part of your divorce was trading assets, and say you have a very large money market account or Fidelity, or there's money invested that was part of your portion of the divorce, we can deplete that asset without moving it at all and just equate that to a monthly income to help bolster your normal income to qualify. So there's a lot of creative ways that I think mainstream people just haven't really heard of, because you think W-2 income is all I can use, or if I'm self-employed, I'm going to have to stick to my taxes. That we all alter our taxes a little bit and increase our write-offs, and that lenders only look at your bottom line. But that's actually not the case. There's a lot of creative lenders that I work with that can help bridge that gap from what you think is affordable to what is actually affordable.
It's great that you're a broker, because then you've got access to all these kinds of programs, right?
Yeah, absolutely. I think a normal lender, which are great if you fall into their perfect little box of lending, they're amazing. But a broker, I probably have 40 different wholesale lenders that I work with for all different scenarios, from the first-time homeowner to the multi-property unit owner that is just building his portfolio, or to just the cash out. There's just so many different avenues for the different people that desire different products.
Oh, wonderful. And we're finding that the primary divorce statistic are the people over 50, over 55 even. We call it the gray or the silver divorce. And one of the things I've come up against a couple of different clients recently where they had a home with almost no mortgage or no mortgage. They wanted to buy their spouse out, but didn't have enough liquidity to do that. And the other person didn't want only hers or something because it's only a monthly payment. So they started to look at reverse mortgage. And it's, I got this home worth 1.5 million. I have to give my spouse 750,000. Maybe I don't have to do it all in a reverse mortgage, but maybe I take a $300,000 reverse mortgage to get enough for them to have a down payment and a home at a price that they can afford, and give them other types of assets for the balance. And be a bit of a hybrid. Again, Ken, does this happen in the courthouse?
Absolutely not. Sadly, we got one tool in the toolbox for the judge if you're litigating, and it's order the house sold and divide the proceeds.
Yeah.
Yeah.
And so there's so many more creative
Technically,
options.
you can defer the sale temporarily. There's a provision for that, but there's so many wickets to get through that. I frankly have never seen it done.
Yeah.
Wow.
We
That's
do it in
incredible.
mediation. We do it in mediation, defer the sale, and we work
And
out
in
what
negotiations, yeah, it's very
in
possible.
negotiation.
Absolutely.
Yeah. And equally, say you do have a mortgage at 3%, and you say to your spouse, and maybe they're like 54 years old, for example. At 55, they also get Prop 19. So
Yeah.
all the homeowners have so think of all the things that you say to your spouse, fine, I'll let you assume this 2.5% mortgage that I'll never get. I'll let you take over ownership of a home whose property tax basis is based on when we bought this 15 years ago. And so for me to, even if we say 1 million, for me to buy a 1 million home, your property tax basis here in San Diego County is what, 1.1%, Emily?
Yeah.
Yeah, between 1.1 and 1.25, depending on Belarus or,
Yeah, the Belarus on top of it. And so that's never going to be equal. So your mortgage is, like Emily says, going to be like mid sixes, perhaps. Like you're going to, so your
it's
monthly
brutal. Yeah.
for a like kind, you're going to have almost a double expense for like kind. And
Easily.
so when you're negotiating, if you're the person saying, fine, I'm going to let you do that, then now it might come into support. Okay, I'm going to let you live in this home, and you're going to have all these reduced expenses, and therefore your spousal support, which ultimately here in California, long-term support is based on need and ability to pay based on the marital standard of living. If I helped you permanently reduce your need, like literally you got 25 more years of mortgage and the right because of Prop 19 to port your property tax basis into your next home purchase. And I didn't get any of that. So my ability to pay also went down because for me to have something similar, I'm paying double. So again, when we talk about saving money, we're talking about strategies now, understanding what this intrinsic value is. And additionally, if you do have children, the parent that keeps the home truly has a home court advantage. I know as a parenting coach that if somebody keeps the primary home and the kids have all the neighborhood established and their school's down the street and these are all their friends, sometimes it's hard to get them to even go to the other parent's house unless they consciously ensure that they're living close by.
Yeah.
Sometimes we're like, okay, the children's furniture is going to the spouse's new home, just so there has to be some movement. You get to sleep in your bed over there and we'll get you a new one over here or something, strategies for.
Yeah.
But ensuring you understand the complexity of what we're looking at here and all the nuance, and some of it's not on a piece of paper. Just say, like, like kind home is this one's going to cost double. Who thought it? You're just not thinking that way. And it plays into the negotiation. As a matter of law, the court doesn't care. And it's just like the value of the home is just the value of the home. They don't look
Yeah,
at
it looks at it in that way, and that's a very limited view.
Yeah. So so that's working with someone like Emily, who's got access to all these different programs, and not just I'm a lender and I work for some company and we have got 4 programs. If you don't fit into it, which is fun. Or or the bartender who decided to become a lender because they wanted to get off their feet. I've seen lots of those. They haven't got the training yet. You've been at this for a long time and very specialized in it. So connect to the right people. It doesn't have to be any of us. We're not only saying it's us, but qualify the people that you're going to work with, so they work for you and build a team. We have a bat line to one another. If I've got a question that you maybe have to go pay Ken for, sometimes I'm like, Ken, can you just answer this question for me? Or Emily, can you just, I'm trying to help these people. Can you just give me an answer? Because
Of course.
we really respect one another and we've worked together for a long time. So if you're going to build a team, make sure your team actually is a team. It's when they got the baseball draft and they, or the football or the basketball, and they bring in somebody to the team that nobody likes. It wasn't an advantage to the team. You just don't build a team where they don't even talk to each other, potentially don't even like each other. Because that right?
Not a team. Yeah. Not a team. Yeah.
Just makes it worse.
Yeah.
Yeah.
And one of the things that Vesta does is team builds, because that's part of their mission and that's what they truly believe in. So reach out to the concierge if you don't live locally to us, and they can help you building a team where you are too. So those are a very significant number of tips kind of categories. Anything either of you would like to still add? Because otherwise we'll move on to some questions and see if we can tackle quite a few of the questions that have come up. Anything you'd like to add?
I think we'll just go to the question for mine.
Sure. Do you want me to call them out to you, Laura, and you can
How
help?
did you do that? That's helpful.
Okay.
Yeah.
Yeah. Okay. So can you address spouse in different state, i.e. me, California, him, Washington? How does this change the process?
Oh, interesting. So the case that Ken and I spoke of, husband was living in Washington and she was living here. So there's jurisdiction. Ken, you want to explain jurisdiction question?
Yeah. So right now, if nobody's filed anything, it's what they call a race to the courthouse. I don't know what Washington and other states' residency requirements are to qualify to file there, but you can look it up. The Google, as my parents say, will tell you. But California, you have to have lived here 6 months, and in the county for the last 3 months, right? You can actually also file for legal separation if you don't meet that, and then amend later to make it a dissolution. So really, like I said, it's up to how the parties want to deal with it, or if they're not talking or not cooperating. If one party really wants to get the process going, in a case like this, if there are two different states that have jurisdiction over a divorce case, as I said, it's a race to the courthouse. Whoever files first is going to have their case started, and if they can get the other side served, then that case is going to be residing in whatever state that is, where the petition was filed first.
Unless if there's minor children.
That's the other aspect. Good point. There's this thing called the UCCJA, the Uniform Child Custody Jurisdiction Enforcement Act. So the UCCJA says that in terms of a state having jurisdiction over children, there's these specific timelines. So wherever the children or child has lived for the last 6 months up until the divorce, that's what's designated as the home state, and where the state is going to have jurisdiction over the child. So in a case like this, if the child's been living here in California, that's an easy call. And California's going to just keep jurisdiction over the child. If the child has not been living here and in another state, that creates actually an impetus to probably give jurisdiction to the other state, because a divorce case isn't going to be handled in two different states. That's just not going to happen. So typically, if there's a situation where the child's been living somewhere and there's UCCJA jurisdiction over the child in a certain state, the divorce case, no matter what's just going to stay there. That's the reality of it.
So if there's no children, it's a foot race, or file for legal separation. I've certainly done that. And then amend, you get to amend one time. And also what's worth looking at, because this question bears on, again, tips for saving money. The couple that was Washington State and here, he had a property premarital and the marriage moved into it in Washington State. And then they moved here. And we have case law, not family code law, more Marsden to do the calculation. In Washington State, they didn't have any such thing as an equitable property state.
Yeah.
So it's a fact driven. You can't just guarantee the math.
Yeah.
So he got legal advice that here, if it's disputed, it's going to be an expensive litigated fact finding mission. Whereas here we had a formula. So he submitted to this jurisdiction because he knew that this would be less costly on that primary issue. Yeah, a particular issue. So we would want to talk to someone like Ken for sure and say, is there anything that this could make it also less expensive or a more expensive jurisdiction to file in, given that we are community property, not equitable property state?
Correct.
Okay. So Yeah, that's a good question because there's a lot of chips just inside that question. Yeah.
Yeah, that's great. Okay, how complicated is it to switch attorneys midstream?
It's for again.
That's a classic irritating lawyer answer I have to give. It depends. Because if your case is like, it's not that eventful and not much has happened, might not be that complicated for the new attorney. If you switch, you get caught up on things. But if you've had a few hearings already and such, it could, it depends on how far along and how complicated things are. Even young cases can be very complicated. I've had cases where they start off with something really unpleasant, like a restraining order, and an immediate 2-day trial on a restraining order. So you're already right off the bat really deep into some very complicated issues that affect support, a restraining order, property allocations that are temporary, child custody visitation. So it really depends how complicated it is. What I tell people is if you're going to switch, get an honest assessment from the attorney who you're thinking of changing over to. And I know it's impossible to say down to the penny, but try to get a ballpark of how much time might be required. Because no matter what, when you switch over, the new attorney is going to have to sit down and read through everything. They're not going to be able to be like, yeah, they already did all the work, so let's just get going and just switch saddles and off we go. It doesn't work that way. They've got to get up to speed and really understand all the dynamics of what's happening. So it's really going to depend on the level of complications in your case and how many proceedings may have happened or what the nature of the proceedings were. So it's a really definitely a case-by-case assessment. It can be pretty expensive. I've had cases where it switched over and there's been like years of litigation. So there's mountains of court files and orders and motions to sort through. And yeah, you'll hear people say, well, that's already been decided by the court. It is true. For example, I have a case where this parties have been fighting about spousal support. Okay. What's coming up, what I've been retained to do is file an RFO to terminate spousal support. The point is, yeah, there are orders in place, but all of those hearings that occurred, there's been a ton over the last decade, literally. What's in those pleadings, the facts that are alleged, the exhibits in those are all very relevant to what's going to end up being litigated at that hearing. So it's going to take a lot of work to take on that case. This is one where it's coming in new, but if you're like in the middle of preparing for that and you switch, you're going to be spending a significant amount of money for the new attorney to get up to speed. So I know that's might not be the most helpful answer, but at the end of the day, it really depends on how complicated and how extensive the preparation is going to have to be for the new attorney. And
Yeah.
that's really
Makes
case by
sense,
case.
yeah.
That's really
Yeah.
the best I can give you.
And also think of it this way, the least expensive way to get a divorce, the least is do it yourself, but almost nobody can do that. So if you have anything to resolve parent planning, custody, child support, spousal support, any assets, don't do that. That's just going to be a mistake.
Yes.
The least expensive, moderated divorce facilitated is mediating with not a collaborative model. The mediator's in the room, you both come into the room. Next step up, mediators in the room, and you each bring your attorneys. You either bring them on a singular issue, like we did in Ken's case, or you bring them for the whole case, and that's called a collaborative divorce, okay? That's the next step up. The next step up is you do litigate, but you take the path that Ken was talking about, where the attorneys are responsively negotiating and not just running the more subpoenaing, more discoveries, more crap. So sometimes if your spouse has hired an attorney whose system does that, because they exist,
Yeah.
you can't stop the train that leaves the station. You can't just put your hand out, you'll get run over. So so when you're interviewing attorneys, you also need to know if your spouse already has an attorney and you've been assigned a judge, you have two immovable objects. You
Yeah.
want to know from a cost saving perspective whether those two attorneys butt heads enough that they're having their own mini divorce at your dime, because that happens, because they're all human, or your
Yeah.
attorney and that judge just don't get along, don't get
Yeah.
respect.
Yeah.
It's fair question. It's
It
fair
is.
question.
It
And
really is.
hopefully you just get just say, I'm curious, like, I know I can't get rid of this judge. What's your experience with the judge? Been in front of this judge before. What kind of success have you had? Is he or she cantankerous, or are they just a baby judge waiting for you to tell them what to do?
Yeah.
Because we got a lot of baby judges here in San Diego County.
You know,
So when you think about this, when you think about moving attorneys, if you don't like what your attorney is doing, the first thing you want to ask yourself is, what is it I don't like? What about this relationship? And how did this happen? Is this just, am I just repeating this?
Yeah.
So the most expensive is switching attorneys more than once and litigating.
Yeah.
The most expensive. And then the next most expensive, then you go to the Court of Appeal. Do it all over again. Now, hopefully you've got millions and millions of dollars you're going to argue about, and you want to make some new precedent that the rest of us can rest on and not have to worry about. So it's a continuum. I had clients in here, and it was really shocking. He was a medical doctor. She worked very high engineer in federal government. They had litigated for about 3 years. They were coming for post-divorce mediation on summer parent planning and nuances of all this stuff that they were fighting over. They said to me that they each had spent close to $400,000 on their litigated divorce.
I'm surprised.
Then they're back in the room with me, and they'd already spent at least about $35,000 to $40,000 more dollars trying to get to their RFO, because there'd been,
Of course.
TV attempts of all this. They came to me and we solved it in 8 hours of mediation. 8 hours. One of their attorneys was trying to not get a wife to sign it and to rewrite some of the provisions. And fortunately, she went, no, stop. I'm gonna have Laura draft it, and that's it. We're done. We're done. Somebody had a common sense moment. And I was like, oh my God, I'm not charging enough. Bloodbath. And the thing is, they had really young children. No, this is going to, so what the stats tell us is if you go to court, particularly when it's a custodial matter, and it was Bill Eddy who's done this study, and he's a very now retired, I believe, mediator and therapist, and he did a lot of studies about conflict, and he was one of my trainers in high conflict divorce mediation training, that if you go to court once with children that are 5 or younger, you're on average you go 5 more times.
Yeah.
Because they mature, they grow, somebody remarries, things happen, there's lots of change. So if you really want to ruin your kids and your pocketbook and your chances of moving on and recovering financially after divorce, litigate with small children. And it's just horrible that your children will have to live with this. So there's a financial cost of divorce, there's the emotional cost of divorce, and there's what it's doing to your children, whether they're babies or adults, because your children are going to be part of this. They can't not be, right? So I want you to think beyond the dollars. I call it dollars and cents, SCNC. Not dollars and cents, dollars and common sense. Bring some practicality to this, because every dollar you save is a dollar you have to live with in your future, to pay forward in your life. Yeah. And once conflict is escalated, it rarely de-escalates.
Yeah.
It just doesn't.
It's a ratchet. It only turns in one direction, unfortunately.
Yeah. Okay. So
a great answer. Yeah. That was awesome. What if finances have always been separate? Does everything go in as community property? And if we have paid 50-50 for the most part throughout our marriage?
Yeah. So what I was saying was, I see this quite often with couples that they just didn't, the new way of apparently living in a marriage, which is probably destined for divorce, is to not share. Anyway, I don't know why you got married, because marriage is a partnership. And so we have community property rules in California. When people mediate, like this couple that I was working with today, where everything's been separate, they're agreeing to keep significant amounts separate that is legally community property. If one of them said, I'm going to court, they would win because the law would prevail, Ken.
Yep, it would.
Yeah.
I mean,
At
the
great
law
expense.
generally doesn't look at what name is on there. If it was acquired during the marriage, it's going to be considered community property.
Yeah. So even if you had a handshake deal but not a prenup, and you treated everything as mine and yours, and I'll pay half the mortgage and I'll pay half the yada yada,
Doesn't matter.
guess what? It doesn't work that way if you go to court. If you mediate, I'm telling you, I'm shocked, because I still put it all on the table. I literally wrote an email this afternoon that took me an hour and a half for this couple, outlining who's willing to give up what and spreadsheeting it.
Yeah.
Because she started off saying I have a $60,000 separate property claim that my aunt passed away, and I put that money into the home, which she did. And then she proceeded to say, fine, you keep your Vanguard account, you keep your retirement, you keep this, you keep that. She doesn't know this yet, and she'll read my email. Maybe she's reading it as we speak, that she gave him back $61,000. So I know she thought, and I know he thought he was giving her 60,000. So it's going to be interesting the next mediation, whether they're going to, she didn't get restored
Yeah.
because she gave it all back. Now, and she might be okay with that. The courts won't do it. You can if your spouse agrees in mediation. The courts don't supervise adults. Full disclosure is required. You're signing a contract, like any contract, knowingly, intelligently, without coercion, duress, with full disclosure. You signed a
Yeah.
contract saying, I don't want your money, even though I know it's ours. Thank you anyway.
Yes.
Yeah,
Exactly.
but most people are not that generous. They're like, I'm sorry, it's ours, and I'm gonna have to live after divorce. So I'm sorry, but even if I'm sorry, I need it.
Yeah.
I need it.
Makes sense. Yeah.
Yeah.
Yeah. Okay, let's see. We have a couple more here. Can the value of the home sold be flipped into a smaller place to buy outright or have a small loan? How soon does that need to happen?
If you sell the home and you get your half, of course you can
Mhm.
buy it whatever you can afford.
Yeah.
Right? That's why you'd be talking
Yeah.
to Emily. What can I afford? What's my
Yeah.
post-divorce budget? Include support if you're getting it, and build it like Emily said, like a lender would do. If you have a 17-year-old and
Yeah.
the child support's about to end, don't build that into your budget. Build into your budget that they're going to stay at home and go to the
Correct.
local community college and keep costing you money, and you may not
Yeah.
get help with that. So it comes down to the budget. And so you're wise to ask the question, what can I afford? I think, Emily, you brought that up. Ask the question, right? Is this something, am I just, people in California, part of the law is, and Ken, you can speak to this too, that everybody gets to live apparently at the marital standard of living. Unfortunately, real estate is so expensive here that
Yeah.
in divorce, the likelihood of still, both of you, still living at the marital standard of living that was accomplished with
Not a
how many
reality.
people living in one home
Yeah.
is practically nil unless they have so much money.
Correct. Yeah.
And even it's probably still not you still have less. How do you not have less? You got half.
Yeah. Exactly. Yeah.
If you got your half, because some of it might have been premarital.
Yep.
Some of it might have been
Yeah.
wasted, all the things we talked about. So it's this, unfortunately, we have this strange myth that's built into our law. The overarching concept of spousal support is the goal is to still be able to both live at the marital standard of living.
Correct.
Yeah. But so understand that when you do your budgets, what I do when clients first start, I have them do their current budget while they're still living together, if they are, and then their proposed budget, what they think they need to live at the marital standard of living. And they're like, oh, the community brings in $18,000 a month. Woo, but apparently you both need 15.
Yes. So good luck with that.
Yeah. So it's a good eye opener that it doesn't exist unless you're going to rob banks or someone's going to get a much bigger job or 2 more jobs or win the lottery. Now you need to say, okay, I have to spend less or work more. That's your
Yeah,
solution.
correct.
You only have 2 solutions. Yeah. Yeah. These are good questions.
Okay.
Yeah.
Yeah, there's a lot of good ones here.
Yeah.
Let's see. Is there any benefit to filing a joint petition for divorce versus regular filing in California? Is it
That's
a good
brand new.
idea, or is
Mhm.
it better to file the traditional way?
So joint petition's brand new. Petitioner 1, petitioner 2.
Fresh
If
for
you-
this year.
If you're litigating,
Wow.
you can't file it that way. So it's only for people mediating, brand new this year.
Yeah. I never
just-
see those.
I know you can't do that. You won't go to Ken and file a joint petition. He probably doesn't even know what the form looks like. But so it says this, we know our date of marriage, and then it says, we're going to decide everything else. You don't even have to pre-decide your date of separation on this form. Whereas traditional divorce says, my date of marriage is this, my date of separation is this. I say our marriage is this long. If the respondent doesn't agree, files a response, our date of marriage is this, and I say our date of separation is that. And now we're going to argue about that. Sometimes it can be quite contentious. And so a joint petition is for those who want to collaborate. You'll pay the filing fee twice. Petitioner 1 will pay, petitioner 2 will pay. I had a case today where they're not planning to lose any retirement assets. Theirs are quite equal. And so we're just filing a traditional, doing an uncontested divorce just to save them a second filing fee. You serve, when you do a traditional divorce, somebody's still suing the other person. They have to be served. And you get 6 months and 1 day before you can be divorced. If you file a joint petition, the day I file it, nobody needs to be served because you both agreed we want a divorce, and service is waived, and that's the beginning of the 6 month plus 1 day. So that's the difference between the two.
That makes sense. Okay.
Good for those who want to collaborate, for sure. It's more humane. I'm not suing you. We're just getting a divorce.
Yeah.
Yeah.
Okay, here's one. If one spouse plans to move out of the country during the divorce, what is important to have in place? Would it be best to sell the marital home?
It's going to depend, right?
Yeah.
So that's
different issues.
yeah. You'd want to
That's
get
a
it.
loaded one.
It's okay. You just probably want to get started as soon as possible, I would say, before the
Yeah.
person's out, because what if you have to serve them? And that's a whole
Sure.
new whack.
Yeah.
Secondly, people can disappear and assets can start to disappear. You can't fetch them from another country.
Yeah.
Very difficult. So once you've started a divorce, whether it's traditional or a joint, you're under automatic temporary restraining orders,
Correct.
meaning you can't clean out the bank accounts, run off with the children, even if it's furry children.
Yeah.
You can't change your will,
Yes.
cancel health insurance. So I have definitely worked with people where the spouse is out of the country, out of state and out of country. In fact, I had a fellow, he was in China. That's a long way away.
Wow.
So we
Yeah.
regulated our mediation sessions, but he's filed here, and he took a professorship in China and moved out. So it all worked out fine. It all worked out fine because they were mediating.
Wow.
And if there's children and somebody wants to take the children, you don't want that to be happening.
Yeah. You want to definitely have
Yeah.
definite orders in place.
Yeah. Yeah.
So, yeah.
Okay, perfect. What if I need to buy a home during the divorce process?
If you need to.
Yeah.
I need to. If they're mediating, I've had couples do that. I actually don't file right away, and they go out and get a second home, and they're both on the mortgage because they can qualify that way. And they both agree to stay on each other's mortgages and work on, but I haven't done it often, but I've had people do that because they had enough money to buy a second property. And then once they're divorced, that'll become his or her new primary residence. And they could always refi later. But again, it depends, right? Do you qualify? And what are you going to base it on if nothing's resolved? Qualify meaning what's my money versus our money?
Yeah, there's going to be a lot of complications. I've run in the situations where I come into a case and one party's trying to buy a house and the divorce is still pending. And in order to close, Emily, you probably ran into this, is like they won't let the transaction close unless the other side signs some type of quitclaim deed.
Yeah, like an interspousal
That's
quick claim.
And of course, the other side is not agreeing to anything and they're dead in the water, lose their deposit. It can be, there's so many things that can go wrong. And I'm talking about in the litigated context.
Yeah.
I'll tell you right now, my blanket advice to people, my clients, is just wait till everything's final. Because in the litigated context, when nothing's agreed to and everything's being fought over, there's just so many risks and things that can go wrong in a transaction like that. It's really not in your best interest.
Yeah.
Just not.
Yeah,
And
I
when-
agree. I have a client that actually just closed on a condo in locally, and they were very amicable. And he purchased the condo before the divorce was final, and she just signed off on everything.
Yeah.
So she
That's
handled
great.
the interspousal and the quit claim. So he owns it, and he's the only one on the mortgage. But yeah, that's so rare. It's so
Yeah.
rare that everybody's
Yeah.
just that in the same flow with each other to let something
Yeah.
like that happen.
Yeah. For
Yeah.
sure.
Okay, let's see if we have some of these are really specific.
We've just got a couple of minutes left. And for those of you who didn't get your specific questions answered, we do offer complimentary consultations because we can't give very specific advice here. We're trying to answer more informational questions.
Yeah.
Do you have one or two more that we should maybe tackle?
Yeah,
thanks
this
for
might
all of
be-
you staying on here. I really appreciate that we've had a big
Oh.
crowd here tonight. And that's really nice to see. Thank you.
Yeah, and some great questions too.
Yeah, lots of things.
So can couples agree in mediation/MSA to use the current HELOC cash out to make the home repairs or deferred maintenance prior to one spouse assuming the mortgage?
Sure.
Yeah, you can agree to
Yeah,
anything
wow.
if you negotiate it.
Yeah.
Yeah. These
Okay.
are all things that are specific to your case and whether you have somebody that you're this is negotiation. And if you're taking the house as is, then you're also getting a discount just like any buyer would. And then you're going to have to budget that it needs a new HVAC system and a this and a that. And you better know what that deferred maintenance is going to cost
Yes. Yeah.
and be prepared.
That makes sense. Yeah.
Yeah.
Okay, maybe we'll do this is probably the last one. So if a family gifts money and it was wired into my personal account over the years of marriage, but became commingled with joint accounts, how difficult is it to reclaim as separate property?
That's a classic. It depends. The starting point in that analysis is there are exceptions to the whole community property rule that anything acquired during the marriage as far as an asset is community property. And you've identified one of them. It's either an inheritance or a gift. When one spouse receives that gift, you have this separate property. By law, it is your separate property. But as happens many times, it gets commingled, mixed in with community assets and used for community purposes. And it really depends on the specific facts. The easy case would be, I got this gift from my parents or whatever, and we spent all of that lump sum on a pool for the house. That's going to be pretty easy to say, okay, that's the bill. It was one lump sum payment to the contractor for the pool in that year. Okay, pretty straightforward. Where it really gets complicated if it gets put into a joint community account and it's just used for groceries, Netflix, the SDG&E bill, that type of stuff. The longer that goes on and the more transactions start to mount that are all community, then it gets really hard to maintain a claim for separate property. At some point, the law assumes that was a gift to the community. So going to depend heavily on the specific circumstances and what can be traced.
Yeah. And it's interesting what I often say to my clients, because this question, she said, oh, it's went into a bank account in my name. If that bank account's in your name, but it was during the marriage, it's not your bank account. It's still the
It's
community.
still community.
Yeah. So what I often say to my clients is think of it like a bouncing ball. If here's the money, it's bouncing ball and it pops in your account and it hasn't been diluted, it hasn't been used for, like Ken saying, different things. And then you plop it into the house or into the pool or something, you can find that's tracing. And so if you can do that in mediation, people go, oh yeah, like the couple today that decided her 60,000 was her 60,000. Funny thing is she just gave back 61. So we'll see how that works out in the next round. Stay tuned. She actually had a larger inheritance than that. And he agreed that she spent 60,000 on a specific aspect of the home and that he was willing to give her that reimbursement for that because the rest was lost and commingled into their accounts. Now, it did go into her personal account, but guess what? It went to her personal account while they were married. That everything was like a washing machine.
Yeah.
If it goes in the washing machine, you can't get it back out.
Yeah.
All right. This has been such a joy having all of you here. I really appreciate all of you. And I hope that you probably felt like you're drinking from some fire hose tonight. So I hope you're not too overwhelmed, but come back for more. We're here every month. If you're in the Carlsbad area, we started doing live seminars, meet the experts kind of thing. We aren't going to do July and August because everybody's got summer plans, but we'll be back in person in September. And we only allow for about 15 people to join us so we can keep it intimate. So that gives you a second opportunity to talk with us, meet with us, and we'll be back in that in September. Next month, Lori Itkin, our CDFA, will be joining us, and we'll be talking about hidden assets, how to find them, and even sometimes really what's not so hidden. Some of which we spoke about tonight. Just open your eyes and learn how to read some of these things. Maybe it's not hidden. Maybe it's in plain sight. It's the elephant in the room that you didn't notice. Yeah. So wonderful, all of you. Say good night, and we appreciate all.
Thank you, everyone.
Thank you, everybody.
Thanks for joining.